continue the discussion on good governance, bearing in mind that the Public Protector should investigate corruption in terms of the Corrupt Activities Act, the Executive Ethics Act, and the Protected Disclosures Act. I'd firstly like to know, would you fearfully and without favor prosecute any person or investigate any person, no matter their political link? You mention, why I raise that question is you mention in your response the whole issue of state capture, and you speak about bureaucrats, but we know that it was very linked to, right to the top level of the previous president. Would you have the courage to investigate right to the top level of politics should the need arise?
Thank you very much, Honorable Swart. Yes, I will investigate any complaints brought to me implicating any member of the executive. I've seriously considered the fact that in terms of the Constitution, Section 182, it says the public protector is accountable only to the National Assembly. So I'm serious about that, and quite frankly, it is not the first time, Honorable Swart, that I had to investigate people in higher authority. In the province where I'm coming from, in the, I don't think it's the right platform to mention names now, but when we were working at the Pretoria Commercial Crimes at the Hawks, we investigated people of higher social standing, and we investigated without fear, favor, prejudice. As long as the facts point towards the commission of an offense, I've always investigated. We have investigated HODs, MECs in the province, and we've got reports that point towards the commission of an offense, and remedial actions were ordered to remedy such. So it's not something, it will not be something new to me. I've done that before.
Thank you very much. And bearing in mind, the public protector can only investigate to a certain point, and then, as we know, with the state capture inquiry, it then referred that to the Hawks and to the National Prosecuting for further investigation and prosecution. You referred to the Zondo Commission. How would you, in the light of the fact that to date, that public protector's report under the previous public protector, you remember the state capture report that started everything, has been referred to the police. Yet to date, we see very little prosecutions. I'm sure there are investigations, but very little prosecutions arising from that. You come from a police environment. How would you address that? You, the Deputy Public Protector, you come up with an excellent report against high-ranking political persons and whoever. How would you ensure that that report is acted on by the Hawks and by the MPA, understanding they are separate, but surely that could also constrain your work? How would you, with your background in the Hawks, how would you assist in that regard?
I studied the Public Protectors Act quite extensively, previously and in preparation for this interview. It indicates that once you have investigated and you identified some of the things in your report, you can refer it to other institutions for noting. As the public protector cannot dictate to the commissioner for the South African Police Service what to do, or the NDPP. But what the public protector can do is to indicate that these are my findings, and you send it to them for noting. What you do is, in the letter that you will first write to that specific functionary, be it the National Commissioner, you indicate this, these are the findings for noting. Obviously, in the correspondence, you will indicate that we agree with the findings, and this is what we will do as the members of the South African Police Services. Then you hold them to account in that particular respect, in that you must expect regular feedback from the National Police Commissioner or the NPA on the progress being made on the investigation, on that particular investigation, but there must be follow-up, and you ensure finally that
Thank you.
that matter is
I'm sorry to interrupt, my time is very limited, but surely there should be some memorandum of understanding or something like that to ensure that action is taken. Yes. Can I just ask you your background with the Public Protector and, of course, with the Public Service Administration, that you require a high standard of professional ethics in the public is required. Is my time finished? Section 34 requires a duty to report corrupt activities. Mm-hmm. Have you ever prosecuted anyone? And if not, why not in that regard? Section 34 of the Public Service Code, the 100,000 Rand provision, are you aware of that provision?
No, yes, I'm aware of the provision. I've never investigated such because in my line of duty, there's never a reason that it be a matter that should be investigated. I've never come across that. But should it come in future, I will investigate such.
Other members? Honorable Horn, Honorable Zele, Honorable Ufuke. Thank you, Chair. Good morning.
Morning, Honorable Horn.
Okay. If you, as part of an investigation, come to the conclusion that there's a specific piece of law, legislation or otherwise, which is really enabling maladministration and corruption rather than preventing it, how would you deal with it in your remedial action?
Yeah, it will be...
Switch off the mic.
If I understand Honorable Horn's answer question is, if as part of the investigation I establish that there is a piece of legislation that enables maladministration rather than curb it, what will I do? Yeah, it will be a difficult one, Honorable Horn, because as members of the Public Service Commission, we deal with the law as it is. We apply the law as it is. I will apply that law until such time Parliament changes it. I don't have the power to say this is a bad law and it should not be followed. So I will follow that law until it is amended through the due processes in Parliament.
Thank you. In the questionnaire on page 12, you deal with poor service delivery on the part of municipalities. And then you make the statement that if you're the Deputy Public Protector and there is a municipality which consistently receives a negative audit finding from the Auditor General, you will institute on your own accord an investigation to determine the suitability of officials, senior officials, the municipal manager and a CFO for that position. Can you explain to us, given the limits or the legislative framework which enables the Public Protector to do investigations and which turns on maladministration, corruption, how you feel you would be able to determine the suitability of senior officials in the municipality on your own accord?
Thank you, Honorable Horn. What I will do, actually I've got quite an extensive experience in investigating the suitability of personnel because that's partly what I do as Public Service Commission. But what I've come to realize is at the municipal level, you have people who are appointed to critical positions but without the requisite skills and qualification. We, as a matter of record, we've got a lot of municipal managers who are teachers by qualifications. But you see, you will see in my report that I've indicated, obviously, that I will not enter the political terrain of indicating the suitability of municipal mayors and stuff, because those are what the political parties determine. But what will I be relying on to investigate that particular suitability? I will be relying first on the Public Protectors Act, because if a person was appointed to the post and not suitable, that may have been as a result of either maladministration or corruption. And in terms of the Public Protectors Act, the Public Protector has got a mandate to investigate all instances of alleged corruption and maladministration.
If you're appointed as the Deputy Public Protector, and others have alluded to the current situation at the office, now there is a perception, rightly or wrongly, that the Public Protector's Office currently finds itself in a difficult space because a lot of what it is asked to deal with and what it embraces through investigations really has to deal with the factional battles of the governing party. So if you go in there at that office, how will you manage that situation?
Honorable Swart, that was our last question.
Thank you, Honorable Hon. I think it is not a requirement to be a Deputy Public Protector, I think. But I think the person who should be appointed as a Deputy Public Protector or a Public Protector must be above politics. Because once your actions, rightly or wrongly, is perceived to be based on politics, you are slowly eroding the trust that members of the public should have in that office, and it will erode your standing within the society. So, should I be appointed to that position, I will not be guided by anything else other than the law and the facts in investigating any complaint that is received involving members of any political party. We need, as Office of the Public Protector, we are not politicians. We are administrators, and we must, to the best of our ability, avoid being seen to be aligned to any political faction of any political party. Because if you look at our constitutional architecture, the Office of the Public Protector does not report to, you don't need any favor from any politician, be it be the president or whoever, because you account to Parliament. You don't account to politicians. You account to Parliament. You don't need to ingratiate yourself to any particular faction. To what end? We should at all times be only accountable to the National Assembly. I think the golden rule for anyone to occupy the office of Public Protector is, it should be, I haven't seen it anywhere, stay away from politics and do the work as guided by the evidence only.
Thank you, Honorable Jale.
Thank you, Chairperson. Good morning, Advocate Nkuna.
Morning, Honorable Member Jele.
I have, okay, a few questions here.
Your voice is too sweet.
I have, my first question would be, with the position that you are applying for, this position needs someone who is aware of the social and economic challenges that our society faces, and is passionate in you must be passionate in your desire to address these challenges that we are facing. Can you please explain what you believe are some of these challenges? You can also use your questions, your answers that you expand on the answers on the questionnaire.
As a country, at this juncture, we've got a lot of social challenges. It's the first time I came to Cape Town last night. And as you leave the airport and come here, on your left, you see a lot of informal settlements mushrooming all over the world, all over the show. I forgot the name of the place. But I think as someone who's used to the place, you might know the place. That is the reflection of the conditions that most South Africans live in every day. There is high unemployment rate, high level of corruption, high level of maladministration, fraud committed against the very poor members that we should channel all our energies towards uplifting every day. We've got state capture. It is a reality that, although it's subject to debate at times, it is a reality that we had state capture in this country, and funds were channeled out of the country to the advancement of the connected few. Those are the challenges that we're faced with as a community. If you look at I once read the report by the SABC currently on the number of protests that they must fizzle out every day due to, I'm not sure if it's lack of political will, incompetence at local government level. We need to channel all our energy towards the advancement of the people of this country, more especially the poorest of the poor. Those are the social challenges that this country is grappling with right now and should be addressed. And by the way, we have enough resources in this country to address those challenges. Thank you.
Honorable Taylor.
Okay. In line with the explanation that you have just given, how would you go about ensuring that the Public Protector's Office makes a genuine impact on lives of the South Africans, ordinary South Africans?
There are usually 2 ways in the main that the public protector can do to genuinely change the living conditions of our people. Through a workshop. At the start of every administration, the members, the public protector will workshop all the members of parliament at national and provincial legislatures and the executive. It is at that moment that the public protector must seize that opportunity and talk to members of parliament and sensitize them about their responsibility. I think the primary role of any member of parliament is to be of service to the people and nothing else. So through that workshop, you cannot attach a monetary value to workshopping any person. But I believe, because we workshop members every day in my capacity as manager at Public Service Commission, we workshop members about the behavior that they must exhibit every day. And I can tell you, Honorable Jelle, that it has an impact in how members of the executive conduct themselves. Although we cannot attach any monetary value to it, but it has been beneficial, it has improved. Secondly, through the reports, like I've indicated previously, the public protector must only speak through the reports. If you receive a complaint of poor service delivery at the municipal level, the remedial actions that the public protector comes up with must be geared towards improving the service delivery to the members of the public.
The last question, Chairperson. Earlier, you responded that you must not be seen aligning with a political party, which is good. You have to be neutral and independent. But, you know, in life, we know that sometimes there are perceptions.
Honorable Jale, we are struggling to hear you.
Oh, you don't hear me, Chair. Okay, Chairperson. Okay, I was just saying, Chairperson, we understand that the public protector, that office, you have to be neutral. You can't be seen aligning with any political party. So I was just saying there are sometimes perceptions. You find that there are issues that are raised and they are not, at some point you find that they are really not the truth, they're perceptions. So my question is that how would you deal with that situation where you find that there is an issue or issues around and they are not proven and they turn out sometimes to be perceptions. How would you deal with it in line with protecting the office of the public protector? Thank you.
Thank you, Honorable Jelle. Indeed, when we have discussion centered around the perception, when we're having a discussion on political affiliation, we say you must not conduct yourself in a way that you may be perceived to be aligned to any political faction. Because your conduct itself, it might be a perception, but if there is a perception, but my reports will vindicate me. Because should it be taken, the report should be watertight in such a way that should it be taken on review, the court will rule in your favor. So, if an opportunity arises that I have to explain myself, I will explain myself, and ultimately, it will be proven that I've never taken any decision based on political considerations. We must always be objective, but our conduct should such that we should not give rise to an opportunity for perceptions. Because even if there are perceptions, imagine if maybe you are a judge, you are perceived to be issuing out partisan judgments. It will just kill the confidence that people have in that office, irrespective of the fact that that is not objective. It's just a perception. We should conduct ourselves in a way that even perceptions, we don't give a room for perceptions to be made about our neutrality and objectivity.
Thank you very much, Honorable Mfuke, followed by Honorable Ndlozi.
Thank you, Chairperson, and thank you, Advocate Nkuna. Advocate Nkuna, you were asked a question about working, if you are appointed to be a public protector, what do you believe in? And you said you believe in teamwork, you believe in making sure that you work together as leaders. And noting what you said and what you know about Section 182 of the Constitution, the powers are with the public protector. And you are saying that you will also look forward that you are assigned the roles. Now, if it happens that you are not assigned the roles by the public protector, what will you do?
Yeah, obviously, should I be appointed to that post, I will expect to be assigned role. That should be the starting point. Because it is a serious, deputy public protector is a position of serious responsibility, and it will be amiss if I were to be appointed to that position and not allocated any roles. But the question is, what will I do? First, I will engage the public protector to establish what could be the reasons that I'm not allocated any other work. Because as the second most senior person in that institution, it will be quite unfortunate. It will be quite unfortunate not to be allocated responsibilities. First, I will engage the public protector to say, this is my, we should work together. I must be assigned serious responsibilities, and hopefully we will be able to resolve that impasse. But should we not? Because I do, as a deputy public protector, I'm not answerable to the public protector. I'm answerable to this committee here. So should I not be allocated work, I will first engage the public protector. Hopefully we'll resolve. But if we don't, then I will escalate the matter here. Imagine a situation where I'm a deputy public protector and I'm assigned here to come and account, and my only answer will be, I was not given anything to do. There is this principle in public service that I enforce, that we must justify the resources that we spend as public service. Because obviously, as a deputy public protector, I will be paid. So if I'm not doing any work, it will be acting contrary to the principles in Section 195 of the Constitution that public administration must be accountable, because I'll be earning money for doing nothing. And actually, there is no greater insult to any professional than to earn money which you did not work for.
Thank you. The next question will be, what is your understanding of the role of the public protector in respect of the requirements of the Executive Ethics Act?
Thank you, Honorable Member Mofokeng. In the role of the public protector, actually the Office of the Public Protector is strategically placed to investigate any allegation of malfeasance against members of the executive in terms of the Executive Ethics Act and in terms of the code. The role of the public protector is to ensure that members declare their interest as they are supposed to be. They are honest to the Republic. They do not act in any way that is contrary to what is expected in terms of their office. They do not derive any benefit out of the position that they hold as members of the executive. and they are loyal to all the laws of the Republic. They do not mislead the President, they do not mislead the National Assembly. So strategically, the Office of the Public Protector has been placed is the only institution that has been given that mandate to oversee the actions of the executive.
Thank you for sticking to your time. Honorable Ndlozi?
Thanks, Chair. I'm going to ask you to keep your answers very direct and short. I just have 5 minutes with you. In your motivation letter, you say you played a role in skills revolution. Which skills did you revolutionize?
I actually made education fashionable, more especially to the elderly. When I was working as a teacher at the University of South Africa, most of my students were elderly people who had given hope in life, and through my actions, we've given them hope.
Which skills did you revolutionize?
Legal and social work skills.
Okay. What is the legal principle in dispute in the public protector's case in court now versus Pravin Gordhan about the suspension of the remedial action?
Actually, the issue in dispute is whether the member of the executive to whom the remedial action has been directed can act despite the fact that the matter has been taken on review. That is basically what the dispute is about.
So what is your view? Should the remedial action of the public protector be suspended? I mean, there are huge implications to that. Any politician can just take it for urgent application for suspension. Don't you see any problems with that? Just your view.
I'm quite mindful of the fact that the matter is before court is sub judice, but let me give you my view. There is nothing wrong. Otherwise, when you say the public protector the remedial action of the public protector must be implemented despite the fact that the matter has been taken on review, the implication of that is that you are giving the Office of the Public Protector the powers of the Constitutional Court. So it is the correct legal interpretation that the remedial action be kept on abeyance pending the review of the matter in court. It is a correct legal position in my view.
So you worked for the police station of Douglasdale for 8 years. Police stations are known to be key centers of corruption as well. Did you ever witness any corruption there, and did you report it?
I've never witnessed any corruption taking place. Had I done so, I can promise you, Honorable Ndozi, I will have reported it.
Then at the Hawks there, did you ever witness any internal corruption? If so, did you report it?
None whatsoever.
My final question relates to, can the public protector take binding remedial action on the NPA?
No.
Why?
It's in terms of the law. When you look at the NPA Act, only the NDPP has got the right to make prosecutorial decision. So if you have the public protector who says, do this, who are acting in breach of that act, and even in terms of the Public Protectors Act, it clearly indicates that the public protector must submit his or her report to these bodies for nothing.
Okay, my final question. Earlier you said we don't report to politicians, you report to Parliament. Isn't it true that Parliament is constituted by politicians?
It's true.
What did you mean?
What I mean is, if you look, you remember the Constitutional Court case by Muhweng on Chief Justice on Nkandla judgment. There is one important observation that we made, that once members of parliament are sworn in, theoretically you cease to be members of your political parties and you become public representatives.
Are public representatives not politicians?
They are politicians, but I will
So you do agree you report to politicians?
I report to politicians, but not in their capacity as members of political parties, but as members of parliament.
Okay. In terms of the legal standing, this question of hierarchy within the legal fraternity is very important, as you know. It's one of the most hierarchicized professions in the country. And there's too much disregard for people who do not come up the ranks and all of that. And this office often requires people with that command huge forms of respect, not only in the legal fraternity, but in society in general. You know, to command respect in terms of your seniority. Do you think you are senior enough for this position? And if so, just take us through what makes you senior.
Honorable Ndlozi, that was your last question.
Actually, I think I'm the most suitable person to occupy the position of Deputy Public Protector, based on the following. Actually, from time to time, I've been given an opportunity. I'm the head of investigation in the province, Public Service Commission, and actually, the role of Public Service Commission is similar to the role of Public Protector. It's just that we deal mostly with public servants, and the Public Protector deal with members of the public. I'm a manager. I have extensive investigative experience. I've worked in a complex commercial crime investigation. So amongst my equals, I'm regarded as a senior public servant, and I consider myself to be such as well.
Thank you, Honorable Livot Regens, followed by Advocate Hisham Mohammed, and followed by Honorable Janji, in that order.
Thank you, Chair. I'm Wilma Neo-Druchen, but voicing for me is not my voice, the sign language interpreter's voice. Just to get back to Chapter 9 institutions. Chapter 9 institutions' roles fall within the constitutional architecture. What is your understanding with regard to that? And then also relating to that question, the mandate of the public protector. There's a possible duplication and overlap of the functions. Now, with the Chapter 9 institutions and the public protector, so as you said, the public protector, the Public Service Commission is kind of similar to the Public Protector's Office. So what is your understanding in terms of the Chapter 9 institutions? And then how can duplications be avoided in terms of these institutions, including the Public Protector's Office? Thank you.
Thank you very much. I think the second part is what is the role of public protector within the constitutional architecture. The public protector has been given an obligation in terms of the Constitution to support and strengthen constitutional democracy. So through my action as Deputy Public Protector, that's what I will be doing to support and strengthen constitutional democracy. What do I mean by that? If I ensure that a go-go somewhere at the corner who is experiencing difficulties in accessing pension for a deceased husband, for instance, that is part of supporting constitutional democracy. If that person says, I'm unable for some reason to get an ID from Home Affairs because every person has got a right to citizenship. So I will be assisting towards achieving that noble goal as enshrined in the Constitution. The other question is there a duplication? I don't think there is a duplication in terms of the role that the public protector plays, because it is strategically placed to ensure good governance in public administration. There are other Chapter 9 institutions like your Human Rights Commission, your Auditor General, but their role as enshrined in the Constitution is not similar to the one assigned to public protector. So I don't see it as a duplicate. I don't see it as such.
Thank you. One more question, Chair. In your view, how do you improve the coordination? Okay, so, and also cooperation with other Chapter 9 institutions? Do you see any benefit working closely with these other institutions? Thank you.
Thank you, Honorable Member. It is very important that there is a better coordination of work that is being conducted or is being done by Chapter 9 institutions. For instance, you might find that a matter that has been reported to a public protector has been reported to another institutions. So if there is no better coordination, there is a greater risk that there can be parallel investigations, and in the process, resources will be wasted, time will be wasted. Actually, in Limpopo, there is what we call FOSAT that I'm part of at the managerial level. That is the coming together of all the Chapter 9 institutions and public Service Commission, although Public Service Commission is a Chapter 10, it's not a Chapter 9, but we come together, we share ideas on how best to take forward our mandate on a time-to-time basis. So I'm playing a role in that. I believe in that. I've done it, and I'm proud to say coordination indeed works.
Thank you. Honorable Hisham Mohammed.
Thank you, Advocate Nkuna. Just a few questions. Earlier you referred to having studied the Act of the Public Protector in detail in preparing for this interview. You mentioned that the deputy is to assist the public protector. Now, what approach would you take if you were successful? Will you wait for the public protector to allocate delegations to you, or would you have something ready? What's your perspective? How would you go into that office?
Thank you, Honorable Mohammed. In government, I've indicated that the public administration is highly regulated. Just like an HOD, for instance, without delegation, there is nothing you can do. But your question is, what approach will I expect? What I will expect is, as soon as I'm appointed, there should be delegations that is assigned to me, because I don't foresee this. I don't see the feasibility of every time a case comes, the public protector will say, "You can run with this." Let's say there are 3 divisions in public service. I mean, at public protector, there is early resolution unit, there is good governance and integrity unit, there is administrative justice and service delivery unit. So, without being prescriptive, but the approach that I will prefer is for the public protector maybe to say, you are responsible for all the cases that falls under, for instance, administrative justice, and service delivery. So you don't have to wait for each and every time a case comes, you establish whether you are delegated to do it or not. Because once you are not delegated, it's illegal for you to actually exercise that power.
Yeah. The question was, would you have proposals before the public protector pronounces on delegation?
Sorry.
The question was whether you would have your own suggestion before the public protector allocates.
Yes, that will be, in our first engagement, that will be my suggestion.
Thank you. Now, in your view, or what is your view as far as the public protector? This is a matter that isn't entirely settled, and that is, must the public protector be a passive adjudicator between citizens and the state as they investigate complaints? Or does the institution have a more investigatory role requiring proactive action in certain circumstances? What's your perspective of that matter?
I subscribe to a proactive role of a public protector. Proactive in the sense that as an everyday, when cases are coming, when you do an analysis as a public protector, you will get a sense of what are the cases that are prevalent, what are the cases that are most problematic in, I mean, members of the public experience the most. And after that, you can create a framework within which you can sensitize all the members of the public. I mean, you can sensitize all other departments. Even if the case has not been reported, to say, be in the lookout of these issues. They've troubled our people for quite some time. So I believe in proactive action.
But how? Will you predetermine a criteria? Or?
The criteria that are used will be based on, it will be analysis of cases reported to the office. If for instance, you've got cases of poor infrastructure provision in Malamlela, for instance. They say houses that are built there, RDP houses that are built there of such a poor quality. You can talk to a housing department in Gauteng to say, these are the structural defects that were identified in Polokwane. So when you contract, please avoid problem 1, 2, 3. In that way, you are being proactive. Other than waiting for a house to be built, when it collapses, you attend to it, you wait for a road to be damaged tomorrow. When in that way, we'll be wasting a lot of resources.
No, thank you. You have read the annual report and studied the Act. Now, what would be the key challenges or risks that the Office of the Public Protector face at this juncture? And what are your suggested mitigating strategies, if you have thought about it?
I've studied the annual report of the Public Protector, and I've identified 2 issues that I think are critical and need to be addressed. First, is there is a backlog of old cases. There are cases that were reported 3 years back that are still outstanding. Honorable Member Mohammed, the Public Protector is not the office of first instance. If you experience a challenge about a particular department, what you do is you try to resolve the matter within the department, if failing which you escalate the matter to the Public Protector's office. So imagine a person has suffered administrative injustice, then after a year of trying, you go to the office of the Public Protector, you say, can you resolve this? So what that basically means is a person might have this administrative injustice has been persisting for a period of at least 5 years. So that is a challenge that needs to be sorted. Secondly, the excessive amount. The Public Protector itself has indicated that that office is spending a lot of money on litigation. It should be properly managed.
Thank you very much. Talking about amounts in last question, Chair. You said somewhere in
Honorable
the
Hisham?
documents that you will,
Honorable Hisham,
yeah.
that is your last question.
yeah. You said somewhere in your replies, written replies, that you noted the NAQ, the no audit qualification, but there's more pride in a clean audit. Now we know the distinction between the two, and then you said you will devise strategies towards a clean audit. You didn't elaborate about what strategies, what tools will you take into account? Not on the administrative side, but actual material side.
Yes. Honorable Mohammed, as an employee at Public Service Commission, we exercise oversight over 12 departments in that province. And where there's been challenges, where there's been qualified audits, for instance, we must come in and try to resolve that problem. The focus has always been in strengthening the Aegis report. It will indicate the areas of concern that you will ensure that the department focuses more on. So as soon as I'm appointed to the office, I will ensure, Public Protector, what is it that needs to be done for us to get a clean audit? Appointments must be done in terms of prescripts, procurement must be done in terms of prescripts. It's possible to achieve a clean audit.
Thank you very much.
Thanks, Honorable Mohammed.
Thank you. Honorable Janji?
Thank you, Chair. I'll be quick. Mr. Nguna, in the 5 minutes, I want to get a lot out of you and also cover my questions. So when I say pause, I want to move to the next point.
Okay.
My first point, so you're saying you're politically aware and at the same time apolitical. So I see a contradiction. It's not the same thing.
It's not the same thing.
You're saying politically aware and apolitical.
Yes.
How can the two be together?
Apolitical, I'm not a member of any political organization. That's my understanding.
Of apolitical.
No. I'm saying apolitical. By that I mean I'm not a card-carrying member of any political organization.
But pause there. So you wanted to say non-partisan, basically, because when something is political, the history of this country is political. Are you with me?
Yeah.
So anything apolitical is denying the history of this country.
Maybe I can say it's a matter of semantics.
Okay, thank you. Let's move from that point. My next point, say the public protector, because what you've said here, you have even said in your, which is very good, I must say I'm impressed with the work that you have done. You've said you would also introduce remedial actions and all sorts of things. Mm-hmm. And I put it to you that you are a deputy public protector if successful, and the area of reports and everything else is not your place. It is the public protector that does that. And then he or she says to you, leave all of that. I want you to go, given your strength, and work with my staff and ensure that the department of the public protector is fully equipped, because you've identified internal controllers and all of those things. And all of the things that you had as a vision are put aside. What would you do?
I will first try to get an understanding from the public protector what informs such.
She will say to you what informs that is exactly what you told us before, to say your role is that of supportive to her. And she'll say, and I would agree with her, that you are here to support me, and I'm giving you these delegations. Leave whatever visions that you have, which are my role. What would you do? Would you leave, or would you go and do the supportive role of looking after the staff?
I will do the supportive role as indicated, because there will be no contradiction. It will be in terms of the Public Protectors Act.
Okay. The next point, you've answered my first question, which is very important, of you having gone through the annual report, and I'm very happy about what the things you have outlined. In that annual report, the public protector says she overachieved the 1920 report. She overachieved on two, meaning she became a president of the African, and that became an achievement. From the Public Service Commission, would you see that as in the mandate of the public protector as an achievement in terms of the indicator?
I also, yes, I can. I also look at the part of the strategic objective of the public protector is to ensure strategic, is to forge strategic relations with other stakeholders. So be it local or international.
Okay.
So that was in keeping with achieving the strategic objective of the office.
Okay, thank you. Let's pause there. My next point, the binding nature of the remedial action. This is what I want to understand to you. Is it absolute? Is it absolute?
It is yes and no.
Yes. Let me hear.
If the subject of the investigation, if the public protector issues a report against Minister X and say this is what the president should do as part of the remedial actions, and the president, the matter is not taken on review, then it must be executed to the latter. But if the matter is taken on review, it must be suspended pending the determination by the court.
Okay, thank you. You've also raised a point in your submission, a point that we raised in the annual report, that the Public Protector's Office is exorbitant on the issues of litigation. And I want you to link that with Section 195 in your space about the economic use of resources and what should be the consequences if you go in there as a deputy public protector. What advice would you give to the public protector about the ballooning litigation cost?
Let me say,
because you've raised that point there, and I agree with you.
I've raised the point.
Yes.
I've seen that as a gap that should.
Honorable Chanje, that was the last question.
Okay.
I've
That's
seen,
my last one.
I've seen that as a gap that should be addressed, because the core mandate of the public protector is not to spend money on litigation, but what will I do to address litigation? Let me be controversial.
Please.
And say the litigation, the ballooning litigation cost at that office is due to perceptions that people have about that office. The litigation cost that we're talking about is each and every case is taken on review, and the public protector needs to defend that. But my advice, should I be appointed to the position, is if a person takes the matter on review, there's no point in defending it. Because if the work has been done thoroughly, what will happen is ultimately will be vindicated by the court, and the legal cost will be paid. The legal principle is...
I get your point. Thank you very much. Here's the last point, Chair. Deputy Director is at level 12. Agreed?
Yes.
The Deputy Public Protector is 15, 16.
Yes.
Quite clearly, if we appoint you, you'll be jumping. You know that. You'll be jumping from 12 to 15. You don't do that in the public service. Why would we do that? Thank you, Chair.
Let me answer that. It will be...
Don't be too long.
Yeah. It will be a jump. Let's agree as a point of departure that it will be a jump. When like I've indicated, that part of my job at Public Service Commission is to check whether the appointments that are made in public service are rational, meaning do they meet the requirements that are indicated in the job advertisement. Honorable Member, I'm actually overqualified for the post. I meet the requirements. I've been in that space that the public protector is operating, and I've done it excellent.
Thank you, Chair. Thank you, Chair.
Thank you very much. Honorable Ndlozi?
Sorry,
question.
Chairperson, it's-
One question.
Yeah, you must give candidate an opportunity to respond to, just so that we don't prejudice him, to Honorable's Breitenbach's disclosure, if he has anything to say. If he doesn't, that's okay, but I thought we should have done that initially, if he has something to say about that. Because
Honorable Glenis Breitenbach says he knows you. She says she knows you. Do you have anything to say about that? And can you also comment about the interview generally?
Thank you, Chair. It is indeed true that I once worked in the same space as Honorable Breitenbach. She was the head of specialized commercial crimes prosecutors. I was working as specialist commercial crime investigators. And as investigators, we reported to the prosecutors that she led. But I've never engaged Honorable Breitenbach on one-to-one cases because she exercised oversight over the investigators and, over the prosecutors who I dealt face-to-face with. So it's true, I know her, but I don't think there is any conflict of interest here, personally. You said I must also comment on the interview generally. It was quite an experience. Tough questions, but it's worth every minute. I'm happy about everything. I just say thank you for the opportunity to come and share with you my vision for that office of public protector.
No, thank you very much. I would like also to take this opportunity to thank you. Being of service to the nation is an ultimate goal, and it's a call. So those who avail themselves, we would also like to thank them. Thank you for availing yourself. Before we adjourn in December, you would already know who has been recommended to the House to be the public protector. We intend expediting this matter, so you'll know very soon.
No.
Thank you very much.
Thanks, Chair. It's been my pleasure.
Honorable members, 2 minutes break so that we don't want to go out during the course of the interview. Can we start? Um, Good day, Mr. Jones. How are you today?
I'm strong, thanks, and you?
Okay, are you relaxed?
Yes, yes, I'm trying to relax.
You have water in front of you. You can sip it to be more relaxed.
Thank you.
Firstly, we'll start with the declarations. Is there any member who wants to declare? Okay. Mr. Jones, can you tell us in 5 minutes your value system as well as your experience and skills that you will bring to the office? And please touch on any experience that you might have in championing constitutional values and fighting maladministration and corruption.
Thank you, Honorable Chairperson. Good day to all honorable members of this portfolio committee. My name is Buwan Jones. I'm currently the acting head of legal at the South African Human Rights Commission. I'm also the Gauteng provincial head, which happens to be the preeminent office in the country when it comes to human rights and when it comes to the South African Human Rights Commission, given the location of the province. It is the economic heartbeat of South Africa. It is the most populous province in the country. My journey started in 2008 when I was employed as a candidate attorney by Legal Aid South Africa in Bloemfontein. I was recruited by Mr. Mashini Mutlou, who was my principal attorney. Following registration of my articles of clerkship, I also enrolled with the University of the Free State Practical Legal School, which enabled me to only serve a year of articles. And I passed my board exams, my attorney's examinations at first attempt with a distinction in one of the courses, accounting. Subsequent to this, I was then thrown in the deep end by being appointed as a professional assistant at one of the justice centers in the Free State. My then principal, Mr. Mutlou, allocated me or assigned me to the regional courts in Tabanchu, Botshabelo, Excelsior, and I did not have experience at the time for the role, but the achievements are there for people who may want to find out what I was able to achieve during my tenure as a professional assistant, as an attorney, representing clients in serious Schedule 6 offenses cases. And there are a number of cases that I won and which I'm proud of. That's why I honed my litigation skills. And I then joined the South African Human Rights Commission in 2010. I started as a legal officer. I then became the senior legal officer after a restructuring. I duly applied for the position. And after our former CEO left the Free State office, I was then entrusted with the responsibility of overseeing human rights work in the Free State. And that is where I made my mark. I spearheaded the investigation into the unenclosed toilets in Viljoenskroon, Ramulutsi. This was in the lead up to the local government elections in 2011. I was part of a team that dealt with the unsavory incident at the University of the Free State, the so-called Rates 4 incident. I was also, together with the team, as I worked with a collective, worked closely with the Andris Tatane family to seek for justice and reparations for what had transpired. The reports...
Mr. Jones, I must advise you, I left with 3 minutes now.
Thank you, Chair. And after my tenure in the Free State, I then joined the Gauteng Provincial Office as the provincial head in 2017. And together with the team, since joining the office 2 years ago, we've again put the human rights agenda in the public domain. Not a week passes when you don't hear about what is the Commission doing in the country and Gauteng in particular. It is because of the young team that is inspired by our values, inspired by our constitutional vision of an equal society that we continue to deliver on our constitutional mandate. And I would like to strongly assert that I'm a product of a Chapter 9 institution. I have found my niche, I have found my calling in defending the defenseless, the voiceless, the downtrodden masses of our people. And I've done this with distinction over the years. I've had the opportunity to chair some of the most important inquiries in this country. The Val inquiry, which looked into the environmental degradation of the Val River system. I'm currently chairing the Alexandra inquiry, which is looking at malfeasance, acts of corruption, and socioeconomic challenges that are plaguing the community of Alexandra. I have chaired an inquiry at UNISA, which happens to be the biggest institution in Africa. And since our intervention, we have managed to restore stability at one of the biggest law faculties in the world, the UNISA Faculty of Law. There are a number of interventions that I've been involved in together with the team. We've recently secured appropriate redress for Mrs. Mathama Ray, who was chained to a bench at a Mamelodi hospital. I've been on the ground. I don't believe in sitting in the office. I believe in connecting with the people on the ground. I believe in engaging with communities directly. And my work has, in the main, been driven by my values as a Christian, as a law-abiding citizen. And I think that through our work, we've been able to assist government, we've been able to assist communities who have experienced maladministration, because there is a link between corruption and human rights abuses. If you look at the recent municipal audit outcomes, and you inquire into the human rights record of the municipalities, you will see that there are strong linkages, and we cannot divorce the two. And my quest for social justice is also linked to ensuring that we deal with the vices that continue to bedevil our people, including all acts of corruption.
Thank you very much. Honorable members, there is a complaint by members of the public that we are not audible. We have received a complaint from Pretoria that we are not audible, including the chair. Yes, so we must try to be audible.
Chair, is that a technical problem, or is it just the
sure.
volume? I think we need to ascertain whether it's a technical problem or not.
Yes, no, thank you very much.
Well, there are some who are not audible here.
No, thank you very much. Mr. Jones, can you please confirm what is in the disclosure questionnaire? And is there anything that you want to further elaborate on what you have already disclosed?
Thank you, Chair. I was required to disclose whether I'm facing any disciplinary or an internal investigation. And I wish to place it on record that I'm not facing any disciplinary hearing or any disciplinary inquiry at the South African Human Rights Commission. There was a request at the behest of the Afrikaner Bond for an investigation to be undertaken by the Commission to look at the appropriateness of my remarks. The Commission has since received 2 external legal opinions from Advocate Ngaitobi and from another senior counsel, Advocate Poso. These 2 legal opinions have exonerated me, and the Commission's fact-finding exercise, I hope, will be finalized in due course. And in terms of our act, the CEO is the one entrusted with the responsibility of maintaining discipline in the institution. And as far as I know, I have not received any formal notification of a disciplinary process against me. Thank you.
Thank you. There's a judgment of the Constitutional Court in Economic Freedom Fighters versus the Speaker of the National Assembly and the Democratic Alliance versus the Speaker of the National Assembly in 2016. What is their fundamental impact on the institution of the Public Protector?
Thank you, Chairperson. This case was significant in the sense that it reaffirmed the important role of constitutional bodies and the Office of the Public Protector in particular. It outlined clearly that remedial actions of the Office of the Public Protector have a binding effect, and by extension, recommendations and directives issued by other Chapter 9 bodies. It solidified Section 181, which establishes institutions supporting democracy. And it also looked into the role played by the legislature or the National Assembly, because I think we should be partners in advancing democratic governance, because we both play an oversight role over the executive as Chapter 9 bodies, and you also do so as members of parliament. And I think this case has set out clear guidelines on how Parliament or the National Assembly should handle reports from a Chapter 9 body. How should the executive authority of the Republic exercise his or her powers? And it reaffirmed our constitutionalism and the supremacy of the Constitution, and that we are all equal before the law.
Thank you very much, Honorable Bredenbach, Honorable Mufokeng, Honorable Hisham Mohammed, Honorable Swart, Honorable Jele, Honorable Ngola, Honorable Horn, Honorable Ndlozi, and then lastly, Honorable Janji, and then Honorable Nivot Dragan will be the last one in that order. Honorable Breitenbach, 5 minutes.
Thank you, Mr. Chair. Good morning, Mr. Jones.
Good morning.
Could you explain to me, please, what your understanding is of the concept of the rule of law and the concept of due process?
Thank you, Honorable Breitenbach. Well, my understanding, I'll start with the due process, is that all administrative actions must be procedurally fair. Whoever is a functionary who is taking the decision must ensure that they have observed the rules of natural justice. They've given parties sufficient opportunity to confirm or to rebut allegations. If in the instance where there's going to be, or there has been an adverse finding, or there's going to be an adverse finding that the person who may be at the receiving end is given an opportunity to make further input. I would make an example in terms of the work that we do as Chapter 9 bodies. So when we embark on an investigation, it is firstly important to establish who are the parties, to establish key issues for determination, and to ensure that all the steps are followed. If allegations have been made, we give a party an opportunity to respond to the allegations. Once they've responded to the allegations, we give the complainant an opportunity to comment on the response from the respondent. And before we make any finding, we need to ensure that we have shared our provisional report with the affected or implicated parties. And once the outcome or a decision has been made, it is therefore essential to ensure, to make sure that we have followed all the procedural requirements to the T. When it comes to the rule of law, it's one of our foundational values in the Constitution. And it enjoins us to adhere to all the legal principles, all the constitutional prescripts and requirements in the Constitution, as the Constitution is the supreme law of the country. And in terms of the work that we do, we are contributing to the rule of law as Chapter 9 institutions.
Thank you. I'll follow up briefly on that question before I ask my next question. And you yourself consider yourself bound by these concepts, the rule of law and due process, and do you always follow them?
Absolutely. I consider myself to be bound by these concepts. Although there was one incident which I need to mention, which involved a prominent waste management company. At the time, I was still in the Free State. I was a legal officer. And the report, the provisional report was finalized without the input of the waste management company, and they then decided to appeal the decision through our internal mechanisms at the South African Human Rights Commission. And since that day, we have ensured that all provisional reports produced by the Human Rights Commission are shared with implicated parties before they are issued to or publicly.
Thank you. You've told us that you're not facing any disciplinary charges. and that there are no investigations currently running against you. And I presume that you're referring to the incident regarding the rugby player, Etzebeth. Is that correct?
Yes.
So you reported as having said about Etzebeth that he even gets away with murder, and we are going to make an example of Etzebeth. Did you say those things? And if you did, how does this dovetail with your views on the rule of law, due process, and the fact that you say you consider yourself bound by those concepts?
That was your last question. Can you answer?
Thank you, Chairperson. I think the comments were taken out of context. And I think it is also important for members of Parliament to understand the role of the South African Human Rights Commission. Our role is very different from other Chapter 9 institutions in that we can litigate, and upon institution of proceedings in the Equality Court, we cease to be impartial because you are not investigating. The moment you are investigating, you become an adjudicator and we have to make a finding. But in the Etzebeth case, we decided, there was a commissioner's resolution that we should institute proceedings in the Equality Court, and I was simply carrying out an instruction of my commissioners. We issued a statement on the 2nd of October, and in our statement, we said we'll convene a community meeting in Langeban, as the community members had requested the commission to come to Langeban so that they can recount their lived experiences. And as they were recounting their lived experiences during the community meeting on the 3rd of October, I was simply rephrasing, I was simply reminding them of the things I had had during the course of the day. So it is correct that I said we'll make an example of Mr. Etzebeth. This statement was made in reference to the criminal theory of deterrence, and it's also in the Equality Act, that because as a country, we should take incidents of racism seriously, given our history. So the statement was made in reference to other alleged incidents involving Mr. Etzebeth and his family and friends, in which it is alleged that the South African Police Service did nothing about it, in which we are informed that even the prosecuting authority did nothing about it, and we said it stops here. And getting away with murder, it was also, I use the word figuratively, because we had been told by complainants, by members of the community, that they had previously reported incidents to the police and nothing had been done. A fellow white compatriot also sent me an email, sent me text messages saying, he stays here in Peru, that I've also been a victim, and I'm still awaiting to hear from the NPA on what they will do about this. I think when we assess the appropriateness of remarks, it is important to have the full context and not to rely on media headlines, not to rely on excerpts, but to get the whole context. And the context I was addressing this community was different in that the commission also has a promotional mandate. And also, as a credible litigant before the Equality Court, we have a duty to vigorously speak in favor of complainants and not respondents. And my statements, like I said, there are two legal opinions from senior counsel, which did not find that there was anything wrong with my statements, and there was nothing untoward or harmful or offensive about my statements, because before, in other cases, the Commission had previously denounced acts of racism in the Akrisi case and other matters we've been involved in. Thank you.
Thank you. You've answered my question. I think brevity is more important.
Thank you very much, Honorable Mfuke.
Thank you, Chairperson. And to Mr. Jones, I want to check if you are happy to be led by a woman, noting that the public protector is a woman. Are you willing to take instructions from her?
Thank you for the question, Honorable Member. I have worked in the human rights space for almost a decade now. And in the Free State, I was led by Lindiwe Khumalo, who is now a legal advisor to the chairperson of the African Union. She then became our accounting officer at the Human Rights Commission. She is one of the persons I have referred to as my reference. She has molded me, she has pruned me, and developed me into being a man I am today. At the moment, my current line manager happens to be female as well. And I don't have a problem with working with anyone. And I actually find it more meaningful to work with women leaders. And I've done so even in my previous work at Legal Aid South Africa.
Thank you. I think I noticed that. That's why I asked the question. I didn't to check who molded you. And it was a woman. Thank you. I just want to check with the information that you gave, you were saying that the Human Rights Commission should at all times work in partnership with the government and the executive. Now, on one of the issues that you actually alluded to, it's about the saga of Alexander, where I saw on TV that you had such a misunderstanding or something happened between you and the MEC in Gauteng. And now the question will be, what is your understanding of the role of the public protector in respect of the requirements of the Executive Members Ethics Act?
Thank you. I wouldn't even call it a verbal altercation with the Honorable MEC Lebogang Maile. I think he misunderstood the question. And our processes are very rigorous and robust because we are enjoined by the Constitution to act without fear, favor, or prejudice. Irrespective of your office or the office you hold, we are expected to discharge our constitutional and legal mandate without fear, favor, or prejudice. And I think the conduct of the MEC, if I look at the EMEA, I think there's an ethical obligation on the members of the executive, particularly if you look at the provisions of Section 181, that they have to protect the effectiveness and dignity of Chapter 9 institutions. And the manner in which the MEC reacted may be perceived, it is not my submission, but may be perceived to be undermining the integrity of the process. But the whole saga was cleared. The Commission subsequently had a meeting with the Premier and his court of MECs. But I think it is important that we, now I'm referring to the executive authority, that we adhere to the prescripts of the Act, and we adhere to the hallmarks of leadership.
Thank you very much. Now I want to check what constructive action can the Office of the Public Protector take to ensure that there's an effective public service which maintains a high standard of professional ethics. looking at yourself working with a public protector and noting the section 182 on the public protector's role?
The Office of the Public Protector has an important role in supporting democratic governance in the country. And its role is vitally important in that it is able to act as an intermediary between citizens on the one hand and the executive on the other hand. And I think there is still room for improvement because much of the focus or the interventions of the public protector, their focus has been more on reacting to complaints, but I think there is a need to be more proactive, to engage with the executive proactively, to identify areas of collaboration, to identify risk areas when it comes to what is supply chain, the code of ethics. There are a number of good examples, and some of these examples are things that the current PP is currently seized with. She's been signing a number of MOUs with government departments and municipalities. And there are two municipalities, for example, the city of eThekwini and the city of Joburg, which have their own ombudsperson offices. Because that's another way of ensuring that we do away, because at the moment there is a focus on the quantitative work of the public protector. She will come to Parliament and say, we've dealt with 50,000 complaints. And I think that her role should be more preventative, should be more on behavioral change. And there are opportunities which I think if I get the role, I will assist her to ensure that we start developing toolkits to ensure an efficient and a responsive public service. We develop code of ethics for government entities. And we also work with faith-based organizations because they used to be very outspoken in the pre-apartheid era, but they have now taken the back seat. And it is about time that we also involve them in as part of an endeavor to change the culture of corruption, which is becoming endemic.
This question?
Thank you, Chairperson. The last one will be on the issue of what is in the media space about the deputies. Actually, I'll say the deputies that have been in the Public Protector's office, how all of them actually worked with the Public Protector. Where do you see yourself fitting? Let's say the Public Protector doesn't assign you any roles. What will you do?
Firstly, I think there has to be clear protocols on the delegation of powers and functions to the DPP. I don't know if that is in place at the moment, but the Act is very silent. It does not outline and spell out what are those functions and powers. And there is a need to establish clear protocols in order to ensure that the public protector becomes effective. And there has been concerns raised by the incumbent, the DPP, and even Mamiki Shai when she was with the Office of the Public Protector. But it is important to understand that I understand my role. My role is more of a supportive role, and I have to align myself with the strategic goals of the institution. And any conflict that may arise should be dealt with internally. Any conflict, when it arises, must be managed accordingly. And courtesy, decency, should permeate our work. And that's how I've conducted myself, because on many of the interventions that I've embarked on at the Human Rights Commission, they were at the instruction of commissioners.
Thank you. Honorable Hisham Mohammed.
Thank you, Mr. Jones. Just a few questions. Before I do, you earlier referred to legal opinions obtained about a matter involving the rugby player. It's just as a matter of procedure. When does the CEO have the commission? Was it the commission's decision to obtain legal opinions, or does the CEO have such delegation?
Thank you for the question. The chairperson of the South African Human Rights Commission wrote to the CEO raising a number of issues which commissioners had discussed regarding the appropriateness of my remarks. And the CEO then engaged with our human resources. The human resources unit at the Human Rights Commission, led by Lakizulu, then decided to obtain a legal opinion on this matter to advise the CEO before he responded to the chairperson.
No, thanks. I just wanted to say where the level of decision is taken to get outside counsel. Now, in your view, is the public protector a passive adjudicator between citizens and the state based on complaints received? Or does the institution have to do more investigatory work, a role playing requiring proactiveness? What's your approach to that? Should they be more proactive, or should they rather focus on the complaints as received?
I think the Office of the Public Protector, they have to find a balance between being reactive and proactive. And given my experience at the Human Rights Commission and what we've done in the recent past, is that we've decided to be more proactive. And the impact thereof is immeasurable. And I think looking at the provisions of the Public Protector Act, there is room for them to conduct, for example, public inquiries, to get members of the executive to account publicly. And it is something that they have not done. You hear about investigations, then a couple of months later, a report is released. But in order to restore public confidence and to ensure that the office enjoys legitimacy, I would want the office to open up its processes I'm all for open justice to members of the public. During the Alex inquiry, the senior investigator who has been assigned by the Office of Public Protector to be part of the inquiry panel told me this is probably the first time they were doing something like that. I know previously they'd done something similar, but in the recent past, he said that this was something that they had not done, and I think it's something they should consider doing. And they should not wait for people to lodge complaints. When we monitor the media, we observe and take matters at our own initiative. And I think I would like to see the Office of the Public Protector taking on more own initiative investigations instead of waiting for members of the public to complain.
No, thank you. What, in your view, are some of the key challenges or risks that the public protector face, and what are the suggested mitigation strategies?
That was your last question.
Well, there are a number of challenges. I think the first challenge is the funding arrangements at the moment. Notwithstanding the fact that the office has received an unqualified audit opinion, there's still are experiencing budget constraints. And this is one of the performance inhibitors because you cannot effectively discharge your mandate with the current allocations. They need more warm bodies. They need more specialized and forensic people to assist in some of the investigation. As this will help by ensuring that they are able to build internal capacity, because there is a tendency sometimes in government, even within Chapter 9 institutions, to outsource some of the work. And it is important to start thinking of a future where we build strong institutions. And part of building strong institutions is to ensuring that we have proper succession planning in place. Since the advent of our democracy, we've not had a deputy public protector becoming a public protector. It is something I hope this sixth parliament will take into consideration, that we really need to have a clear succession planning in place to ensure that by the time the current public protector leaves office, the deputy is ready to take on the tasks. There are other challenges. So the challenge, the quantitative, the obsession with quantity, number of complaints, for me, it should be more about impact. Because when your work is impactful, you are bound to affect behavioral change. Once members of the executive know that if I do this, I will get in trouble, or other organs of state, and behavior starts changing, I think that for me will also assist. And there's a credibility crisis as well at the moment.
No, thanks a lot. Chair, I just wanted to check the acting post that you currently in. What level is that from a public service perspective?
Yeah, I wouldn't know from a public service perspective.
Is it a level 11, 12, 13?
I think it's a director level. Yep.
Thanks, Chair.
How many people report to you?
In total, it's because head of legal services is also responsible for provision of legal services nationally. So there are about 9 provincial offices. And the commission in total has close to 50 legal practitioners. And we also are a registered law clinic. Yep.
Honorable Masako Chele? Oh, you're not? Okay.
We can't hear you.
Oh, sorry. It's Honorable Ndlozi, followed by Honorable Swart, and then Honorable Nivot Regens, and then Honorable Masako Chele, and Honorable Kola. Lastly, it will be Honorable Janji. Oh, okay. Honorable members, don't develop your own lists. Let's have one list. One list that must be voted for. Honorable Dr. Ndlozi?
Thanks. So you are essentially applying to deputize Advocate Mkhwebane. She has been losing a lot of cases recently, and many people feel she should go. They think she's incompetent. What is your view of the work that Advocate Busisiwe Mkhwebane has been doing?
Thank you, Honorable Ndlozi.
We don't have time, Chief.
Yes.
Push.
Yeah. Well, I think her work has been commendable. I wouldn't want to focus on the review applications, it is common practice that when you are dissatisfied with an outcome of an investigation, you can exercise that right to apply for a review. But if you look and quantitatively at the work that she has done since she's assumed office, I think she has done well. There are areas of concern, but I still think there is room for improvement and she needs to be supported.
So what improvement do you think she needs?
Well, one of the key things, because there has been a high staff turnover. So it's selectivity in recruitment and recruiting the right people to assist her to discharge her mandate.
So you were talking about funding earlier on. It's a big problem in that institution. Would you go and fundraise in other countries?
I wouldn't think it's something that is appropriate to go and fundraise in other countries, because funding comes with conditions. And this is an institution that is supposed to champion good governance, and that is supposed to demonstrate or to display ethical behavior. And I wouldn't advise her to get funding. I think the office deserves funding. Recently, the Minister of Finance allocated 1 billion to the National Prosecuting Authority.
So
and if you are serious about fighting corruption, we should
that's
also
fine. That's fine.
fund this office.
So let's talk about success. On what grounds would a deputy public protector succeed a public protector? Is that legal, that they follow each other? Like, I didn't understand what you meant.
No, it's not automatic. The DPP is not entitled to become.
So you're saying
that
Parliament must appoint deputy public protectors as public protectors when the public protector ends?
Honorable members, let's try and balance questions not to be just a cross-examination.
We don't have time, Chair, and the candidate takes long pauses, like Mandela, so I'm not going to allow him to do that. Yes, Chief.
Yeah, a quick one. And this is a good example. Look at the office of the Auditor General. Kimi Makwetu succeeded who? Before him, clear succession planning. Why has Parliament in that instance done that? If you look at IEC as well. But I'm not saying it is automatic. You still have to be subjected to a competitive process. Yep.
This is going to work against you in a very huge way. But it's fine. Let me canvass. You just turned 35 on Saturday. Or was it Friday? One of those days.
On Saturday.
On Saturday. It's a very young age. I'm young. The age get to be used against us a lot. So you'll be investigating people who think they are veterans. You'll be calling, having to stand against huge criticism. Can you say something about how young you are in relation to the role and the expectations in it, so that later on when we debate, we can use whatever answer you're going to give. That office is that important, and the people that it investigates will insult you sometimes. But the quick one will be your age. What's your reaction to that?
That was the last question, Honorable Ndlozi.
I don't think age should be used as a consideration when considering a candidate for this position. The mere fact that I've been shortlisted means I meet the requirements for the position, and I'm equally competent as other shortlisted candidates. And what makes my position more unique is that I've been in the Chapter 9 space for almost 10 years now. I've chaired inquiries, high-profile inquiries. Ministers have appeared before me, MECs, mayors, and I have continued to fiercely discharge the mandate of the Commission.
Thank you. Last question. What is your view on the conduct of the outgoing Deputy Public Protector and the ways in which, both in relation to Advocate Mkhwebane and Thuli Madonsela, he has been taking a tangent? What is your view in relation to that conduct, and do you approve of it? If not, would you act differently if you hold strong views that are differing to your boss? Thanks. That will be my final
That
question.
was the last question. Final one.
I think any differences of opinion must be handled internally, and that is how I'll approach my work should I be appointed, to handle all differences internally, to find common ground on issues, and to use all those issues that are common ground as a basis to find a resolution.
Thank you, Honorable Swart.
Chair, and thank you, and happy birthday for Saturday.
Thank you, Honorable Swart.
The issue related, you practiced as a lawyer. When you have a personal costs order against a client, it is a severe indictment against that person. Would you agree?
I do.
And so when the court gave costs order against the existing public protector, it is a severe indictment. You'd agree with that? In terms of your first, yes or no? It's easy.
It is an indictment.
Thank you. Thanks. Because you did say, you balanced your answers. You said there are areas where she's done good work, and there are obviously areas where there are concerns. I just wanted to clarify that issue. Secondly, as acting legal services for the Human Rights Commission, when the Human Rights Commission comes before us, they say state departments do not comply with their orders. How will you, being a Deputy Public Protector, ensure that state departments, and in particular politically aligned persons, ministers, comply with the rulings of the Public Protector? Very briefly, I don't want to be rude, but I've got very limited time.
Yeah, I think the Public Protector should use her powers. She has subpoena powers, which are provided for in the Act. The Commission, we have not really used our subpoena powers, but I think the Office of the Public Protector should proactively engage with government to ensure cooperation. If there's no cooperation, to use its subpoena powers.
Thank you very much for that short response. Now, one of the acts which you're going to have to look on, which the Deputy Public Protector and the PP looks over, is the Protected Disclosures Act. In my view, whistleblowers are not sufficiently protected. Take the example of Mr. Tabiso Zulu, a whistleblower for political killings in KZN. What would you do to strengthen protection for whistleblowers, given that the Public Protector has to look and oversee the implementation of the Protected Disclosures Act?
I think there has to be a structured and a formal arrangement between the Office of the Public Protector, the Ministry of Police, and the National Police Commissioner to ensure that all whistleblowers are protected.
Would you recommend amendments to the Act to improve protection for whistleblowers, given that the Public Protector oversees the implementation of that Act?
Yes, I would be amenable to legislative changes, given the high levels of corruption in the country.
One of the concerns is your lack of forensic skills and forensic investigative skills. Do you not think that that would count against you, given the fact that you highlighted the issue of corruption, but that you don't seem to have enough experience in that area, whilst you're an excellent legal background? But forensics is obviously a big issue that the Public Protector needs.
Well, it's one of the developmental areas that I will seek to attend to should I get the role.
And then some of the issues relating to the concerns around the Public Protector at the moment, in as much as non-compliance with, when one looks at orders are brought, and if you look at, for example, state capture, which we're fully aware of, where it was referred to the NPA, to the police for further investigation, we see very little happening in that regard. How would you ensure that those public, when it comes to the institution of criminal action where necessary by the NPA and by the Hawks, such as the state capture inquiry that was almost 3-4 years ago brought out?
I think it is important for to establish synergies between all the anti-corruption bodies in the country And the public protector is an important stakeholder, and there should be a mechanism that is found in order to ensure that there is compliance, there is consequence management and prosecution for those who are involved in acts of malfeasance.
Thank you. And then lastly, you headed the Vaal River System inquiry, which related to the water issues. But we see still today that's even in a worse situation. Do you think that the Human Rights Commission and your role there was insufficient in dealing with the drought crisis in Gauteng? Or was it just a case of non-compliance with your recommendations?
We have not yet issued the report in this matter, given the complexity of the issues. But there are a myriad of factors that have contributed to the challenges in the Vaal, and they stem as far back as 10 years ago. Save the Vaal had obtained close to 8 court orders against the Mfuleni municipality. Notwithstanding these court orders, the municipality did nothing. There is currently a report from the SIU about alleged acts of corruption at the municipality. So there are serious challenges, and the municipality is currently under Section 139. It has been placed under Section 139 by the provincial government, and we are hopeful that as soon as the report is released, we'll be able to find lasting solutions.
Thank you for your very quick responses. I do appreciate it.
Thank you very much, Honorable Jale.
Thank you, Chair. Good morning, Mr. Jones. My question quickly is why do you think that the Constitution requires that the public protector must be both independent and partial?
I think this emanates from the constitutional requirement that the office itself must be independent, must be impartial, and must discharge its constitutional and legal mandate without fear, favor, or prejudice. And the person who will assume the role is therefore expected to become the embodiment of all these legal requirements and values.
Your views on the consent that the office is not, what is your view on that?
Well, we cannot pass judgment on the office on the basis of few judgments. How many reports has the office released that have been taken on review? How many complaints has the office finalized over the 3-year period since the current PP took over? So I think we need to get a balanced perspective on how the current PP has discharged her functions.
How would you go about ensuring that the Public Protector's Office make a genuine impact on the lives of the ordinary people of South Africa?
I think there has to be early resolution of complaints. I know they have a unit that focuses on early resolution of complaints, but they should strengthen that to ensure that the members of the public get their matters resolved as speedily as possible. So I think the focus should be on early resolution and high impact work.
My last question, Chairperson. How would you deal with the perceptions around the public protector's office that sometimes the office has been accused of aligning with a certain political party?
Well, these are perceptions, and we can't control perceptions. But the key thing is that the public protector should ensure that all the reports and the work that the office does, everything is done within the prescriptions of the law, is done without fear, favor, or prejudice. There will always be accusations. I was at some point also accused of being a DA member after I made findings against another political party. I was accused of being EFF after I made a finding against another party. So it comes with the territory, it comes with the job, and we should always consider constructive criticism because we are accountable to the public and to Parliament as the voice of the people. So we should not just ignore the concerns raised. We should use those concerns to build on them and try and reposition the office to reclaim its status in the country again.
No, thank you very much, Honorable Jale. You have saved some time. Honorable Kola.
Mnumzana Jones, we are looking for a deputy public protector, a fit and proper person. And part of what defines fit and proper is honesty. Do you honestly think that Ben Etzebek is a racist lunatic that must be isolated from society?
Thank you, Honorable Member. As we speak, there's a prima facie case of unfair discrimination and hate speech against Mr. Yetzebeth.
Thank you. You have worked for Legal Aid South Africa, which you have defined as a backbone of the most downtrodden masses of our own people. Check in terms of the constitutional mandate of both Legal Aid and the public protector. Do you think there are similarities? If the answer is affirmative, what are those similarities?
Well, there are some similarities in that they provide legal advice to complainants, but Legal Aid is empowered to litigate. And I think maybe the time is ripe now to broaden the mandate of the Office of the Public Protector to do what the South African Human Rights Commission is currently doing, taking matters to court. We should also consider broadening the mandate to include focus on non-state actors. If you look at other ombudsperson's offices around the world, some of the work they do also focuses on the role of corporations in the country.
Thank you. Looking at the mandate of the Public Protector's Office, do you think that there is an overlap to the mandate of other public institutions? You speak of your SIU and etc.
Yes, there are overlaps. The office only has exclusive jurisdiction on EMEA, but it has complementary jurisdiction on corruption and other related matters of maladministration. And that is why I have called for greater synergy and collaboration between all these anti-corruption bodies and public service bodies that seek to advance democratic governance.
What do you think must be done in ensuring cooperation between the institutions whose mandate clash at some point?
Well, it starts with establishing a referral mechanism. There's a tendency by complainants to forum shop. They will go from Legal Aid South Africa to the Human Rights Commission, to the Office of the Public, complaining about the same thing. So there is a need to ensure that there's greater clarity on our respective roles and mandate. There's a proper referral mechanism, a memorandum of understanding. Luckily, with Chapter 9 bodies, we have a forum of institutions supporting democracy. So to address some of those concerns around the overlap of mandates. For example, I've deliberately, together with my colleagues, not pronounced vociferously on issues of gender-based violence because we thought that we should allow the Gender Commission to take the lead when it comes to GBV, although it is a human rights issue. And this takes me to the Karasmal report, which is calling for a super human rights body. Maybe that's something that the 6th Parliament should also look at.
Thank you. Judging is the last question, Chair. Judging from the fact that the Public Protector Act is silent on the delegation framework of the Deputy Public Protector, what would you do if you see that there are great irregularities done by the Office of the Public Protector in a certain investigation?
Well, I would have to obviously raise this or take this up with the PP. And if it remains unresolved, it will have to be reported to Parliament as she's appointed, as she accounts to this House.
So the use of media is not a priority in this matter?
No, we should only use the media to advance the work of the office and not to undermine the work of the office.
Thank you very much, Chair.
Right on time. Honorable Hon.
Thank you, Chairperson. Good afternoon, Mr. Jones. Taking you back again to the Langebaan meeting, what have you learned from that experience, and if the situation could be, let's say the clock could be rewind, would you handle the situation differently at all?
What I've learned is that there is a need for a greater understanding of the work we do as the South African Human Rights Commission. We play different roles when we are investigating and adjudicating complaints. We play a different role when we litigate, and I don't think this has been adequately communicated to members of the public. And I think it is also important that when you engage publicly on these matters, to engage so responsibly. And I think it is one of the lessons that it is important to engage responsibly. And even though you are allowed as a lawyer, because I'm the attorney of the record, to vigorously advance the case of the complainants, but it is also important to engage with the media and the public in a responsible fashion.
Thank you. In your answers and the questionnaire even, it's quite clear that you are a proponent of proactively engaging government. And it is so that the Public Protector Act itself also makes mention of mediating matters. How should the Public Protector's Office find a balance between mediating, which I think in the lived experiences of many South Africans could boil down to deferring to government all the time, versus taking remedial action that will make an immediate positive outcome to the lives of people?
Yes, if you look at what has happened over the last decade, there is a drive towards court-aligned mediation. I'm an accredited mediator, so I'm a big proponent of mediation to resolve these disputes because of prohibitive legal costs. Litigation in South Africa is very expensive, unaffordable, and denies ordinary people access to justice. And if you look at the key attributes of any mediation process, and one that really stands out for me is it is a win-win situation. And it should not be perceived as succumbing or capitulating to government. As long as the process is explained from inception, I think parties who are involved in the process should have full confidence in it.
Okay, the bulk of your time at the Human Rights Commission more or less was spent in the Free State, where you were at some stage an acting provincial manager and then even a provincial manager. So in 2013, the Human Rights Commission brought out a report in respect of water provision in, I think, about 26 towns in the Free State where people had either intermittent access to water or no access to water at all. And that specific report made very specific, conclusive findings that the specific local governments violated one of the most basic rights people had. Yet, until the time you left the Free State, nothing other than mediation happened on the basis of those findings. So, should you not have used your powers to take the matter to court, firstly? And secondly, will this be the way you want to deal with matters at the Public Protector's Office, by making conclusive findings but then trying to talk nicely to government?
Thank you. This complaint was lodged by Patricia Kopani, a member of the Democratic Alliance. It was a complaint against Kopano municipality. We made very clear findings and recommendations which were not complied with. Subsequent to the release of our report, we engaged with the Office of the Speaker. We also engaged with the DG in the province, Mr. Kopung Radikonsani, to urge the provincial government, to urge the legislature to ensure that the municipality implements our findings and recommendations. This did not happen. What we should have done, we should have issued a subpoena notice to the municipality, firstly. And we did not do this. And if you look at, over the past 5 years, we've not really used our subpoena powers as the South African Human Rights Commission. We've used it in some instances, and I think there is a need where we have recalcitrant respondents that we invoke our powers which are provided for by the Constitution.
That was your last question?
I really, Chair, I don't think so. I really think my 5 minutes is not up yet.
No, you started at 12:32, it's 12:38 now. Honorable Janche.
Thank you very much, Chair. I hope I'll be brief and stick to the 5 minutes. Mr. Jones, I would prefer that you become a sharpshooter. I want to, in my 5 minutes, get what I want to ask and get the best out of you. Have you, in applying for this position of the Deputy Public Protector, done research on that office to understand it? Yes or no?
I have chaired meetings of the Forum of Institutions Supporting Democracy, so I have a sense of what the office is doing. And
I'm specific. Before you came to this interview, before you applied, when you filled in questionnaires and before today, have you just done research about what is entailed in that office?
Well, I've asked colleagues who work there what are some of the concerns and challenges. And some of these concerns were raised at our FISD forum, so they were nothing new to me.
That's fine.
Yeah.
Do you know what is the budget of the Public Protector's Office?
I wouldn't say I know, but it should be way above 200 million.
Okay, let's pass. Do you know what are there are 3 programs in that office. Do you know what are those 3 programs that make up that Office of the Public Protector?
They have a unit that focuses on good governance. There's a unit that focuses on early resolution of complaints. And I think there's one that focuses on ethics.
Okay.
And yeah.
That's fine. The 3 programs is administration, investigations, and stakeholders. But let's leave that. You did indicate earlier on that in your view, that office is doing well. If you had checked the annual reports, it would indicate to you that in 18-19 financial year, they achieved 50% of their own planned targets. In the 19-20 financial year, they achieved 72%. You consider that doing very well?
Well, there may be other contributing factors. And working in the human rights space and the Chapter 9 space, there are a number of performance inhibitors, which I'm not privy to. And hopefully when I join the office, I will get to understand what are some of the challenges.
Okay. Yeah. Thank you. Are you a firm believer in the Constitution as a supreme law of the land?
Yes.
Okay. Now, am I right to conclude that the statement you made in your submission makes me to conclude that you are not a firm believer of the Constitution as supreme law? And let me read that to you. You make a point and say, while we have a so-called impeccable Constitution and Bill of Rights, that statement, I stop there. A so-called impeccable Constitution and Bill of Rights is a statement from somebody who does not firmly believe in that Constitution. Am I right?
We have a highly acclaimed constitution, but this has not translated into material changes for our people. Issues of land justice, issues, I mean, we still have the massive inequalities in the country, the scourge of racism, high levels of corruption, maladministration.
That's the next point. I'm not there. Where I am is the Constitution and the Bill of Rights. Was in my understanding, once something is referred to as so-called, you're casting doubt on that. Are we together on that?
No, I hear you. There wouldn't be calls for an amendment of the Constitution if it was impeccable. So there will be times where we need to review as a nation to look at the impact of the Constitution since the advent of our democracy.
Okay, thank you, Chair.
Thank you, Chair. Just a short question. I'm not going to use all 5 minutes. I'm Wilma Neodruchen. Voicing for me is my sign language interpreter. Now, your work that you do, you know, many conflict resolutions, etc. But I would like to ask, in your team, if there has been conflict, because obviously you get differences in opinion. So if in your team there would be conflict resolutions, how would you resolve it? Because each team member have their own opinions. And then can you give us an example of, in the work that you currently do, how you have resolved conflict in your own team or in management, on management level? Thank you so much.
Yes, there has been instances of conflict. And one example would be the SuperSport inquiry. We wanted to conduct an inquiry into allegations of racism and racial discrimination at SuperSport. But we held differing views on the approach and as to who should be invited. And the colleagues involved were able to persuade me. And it's not about me, it's about the organization. And I agreed that we would need to obtain a legal opinion, we'd need to speak to all the parties before convening such an inquiry. And it is through, because I'm a team player and I listen and I take advice and I listen to the advice of colleagues. And that's what I've done to sort of manage conflict in the office. But I'm also a very assertive leader.
Thank you very much. Honorable members, we have been able to save some time. We will not be able to call another candidate in 15 minutes time. So we will spend this time if there are any members who would want to ask further questions so that we can just finish the 15 minutes.
We can take a break, Chair.
Well,
And in that break, we must.
I'm already on the floor. Yeah. Yeah, thank you. I wanted to ask Mr. Jones,
but we break now and start.
In response to a question by Dr. Ndlozi, he said that all differences of opinion with the public protector should be handled privately, internally. However, there may be a situation, let's make a hypothetical example, where you arrive at the office having been appointed and you are informed that you are tasked with only developing a case management system and training. And despite all of your mediation skills and your negotiation skills, that remains the decision of the incumbent. What do you do then?
I would constructively engage and interact with the PP on these areas of concern and find an amicable solution. So I wouldn't just walk in there and impose myself or my will, and I would have, and like I said earlier, I would urge her to start the process of establishing clear protocols on delegation of powers and functions, so that I stick to my lane and I don't assume some of the important functions.
Sorry, Chair, and one more. So of late, even though it was not that high a profile matter, you were also embroiled in another bit of an issue in the media, and you today informed us that you're very proud of getting reparations for the Gogo who was tied to the hospital bed in Gauteng. But towards the end of last month, you were in a Twitter spat with the Gauteng Department of Health when they announced that there was this settlement and you denied it. So what happened there, and how is it that today you say you're satisfied that there has been achieved reparations?
I wrote to the department to express my misgivings around the handling of this matter, and the department has agreed that we should have handled this differently, because one of the key features of any mediation process is confidentiality. So even before the family had signed the settlement agreement, the department was already making public pronouncements. And as we speak, the family has signed the settlement agreement, and the MEC for Health in Gauteng will be making a public apology on the 20th of November.
Any further questions, members? None. Mr. Buang Jones, thank you very much for answering our call, for making yourself available. We don't take that lightly. Thank you very much for making yourself available. Can you comment, how did you find the interviews? And if there's anything that you would want to say before we release you.
I would like to commend the committee for shortlisting me. I'm subject to correction. I'm probably the youngest candidate. I'm 35. My last year as a young person. And it's a vote of confidence in the youth of South Africa. And I hope through this interview, I've inspired many young South African lawyers and young law students who one day want to play a role in strengthening this democracy. Thank you.
We intend making a decision very soon. Before we adjourn in December, we would have appointed, or would have made a recommendation to the House. So you'll know very soon about where you stand. Thank you very much.
Thank you.
Thank you. Honorable members, can we meet at 2 after lunch to deal with the last two candidates for the day?